Good morning. It is not good evening. Ooh, how are you guys doing? Hey, Fleshman. Thanks for the link. Has it really been September? Wow. I don't think so. I don't know. No idea. What's up, Gabby? How are you doing? I hope I'm not messing with your schedule too much today. Here's what I'll show you what I'm seeing in the courtroom. Oh, that's not true. Flash fan. No way. Good morning, Annabelle. How are you doing? How's your AC situation? Hope that is fixed. It is hot, hot, hot. I'm gonna unmute it. There's no sound, but just so when it comes on, I have it. I have it boosted. I don't have it all the way. I don't. If it blows your eardrums out, I apologize. If you can't hear it, I'll try to fix it. Well, Gabby, hopefully this won't be like a super long hearing. I don't know why it needs to be. I think she should walk in and the judge go, no, denied, bye. You won't have AC until September? Oh my gosh, Annabelle. Wow. I'm sorry to hear that. You know, I would assume so, Flash fan. I have no idea. I don't know what's going to happen. I'm really just kind of excited that her defense attorney that we watched yesterday may be called as a witness for the state. That is what I want to see. Because, or we could just roll the footage of her testifying. Like, oh, hey, were you not competent right here? Or is it just your memory? Do you know? Hi, Tracy. Hey, Zach. I actually have a rare day. I don't have my granddaughter. I have her tomorrow and Sunday. And this woman is asking for a new trial. And I have a chance to do it live, so I'm going to do it live. How are you doing? And I know it's like Flashman had to set like 6 alarms to get up this morning. Tracy, how are you doing? Hope things are settling down for you. Oh, we have sound. I don't know if we need it yet. What does that sound like for you guys? It's just chatter, so it may not be very loud, like at all. I don't expect it to be, but as long as you can just hear some chatter.
You got ones up on the bench.
Probably gonna speak most of that way. You're good.
I think.
No. Is there going to be any witness testimony or testimony? Okay.
You guys are calling witnesses, right? Between you.
We might. I mean, depending on what. Yeah, we're ready to. If
Oh, there he is.
If you see something pop up waiting room,
I'll come let you know.
and just yell at me.
Yep.
Oh no. Oh, no. I'm sorry, Gabby. It's because I told her I haven't told Brandon and Bree yet, but I've told everybody else like I'm not available today. I'm streaming this morning, and then I'm going. It's going to be 102. I'll be in the pool. Like I'm not available today. Today is my birthday is Sunday, so today is my day. I'm celebrating my birthday today. I don't care if I do it by myself. That's the way it is. She will deserve it. She better be here. She better be here. I know she won't be here. Well, thanks. Thank you very much. I appreciate that. I'm not quite there yet. Don't rush me. I don't know. I've like been trying to remember how old I'm gonna be, and I haven't cared enough. It's 50 something. I think 52. 52. Well, what else do you say? I told her to be here. Yes, I have a birthday. I will be spending the day with my granddaughter that day. So, yeah, well, Flashman, sorry, the older you get, the less you care. Like, you just, I will tell you, I'm going to mute them. I was telling a friend of mine the other day, she's in her 70s, but I was telling her, I was like, I love being 50. I have loved being in my 50s. I don't care. Like, my care level about what I do, what people think about what I do has went, I don't care. I don't care. Like me, don't like me. It is what it is. It's like, yeah, that came on my 50th. I was like, thanks. Thanks, AARP. Thank you, Annabelle. Thank you, Gabby. I saw that it might rain today. I was like, you better get out, clouds. You got till I'm done. It better be sunny. That's it. It's the rules. All right. I love how this guy's telling everybody how to use the microphones, which is great. Let's hope they do. No, you haven't, Zach. Thank you, Tracy. Sorry. They just said something so weird. That is my plan. I don't know if I'll have any cake. I was going to buy some brownies to make today, but I didn't. Oh, they just cut the sound. All right. I'll turn it back on then. They said something about she's going to sound like a disembodied voice. I was like, what are you guys talking about? Shanda, whatever. No, I don't have special brownies. I don't do those. Oh, I haven't had any of that in months. My husband doesn't like it, so it doesn't really do me any good to make it. So I'm not going to eat a whole key lime pie by myself. Good grief. If I did, I'd have to like go sit in my car and cry and eat it alone, like somebody just broke up with me or something. Or if I just looked down and I had realized I'd ate the whole pie, then I'd probably just have to go cry somewhere. My husband would eat the lemon. I'm not a big lemon person, but he wouldn't eat the meringue. He wouldn't like peel the meringue off. It's weird. Thank you for the super chat. Zach, Flash fans number 1, I demand a recount. I turned mine off, so I can't see what y'all are. I can see your number 3 in your super chat. That's weird. So I can't recount because I don't have a way. Maybe I can see it. Zach, it says you're number 1. Flashman's number 2. Tracy Dane's number 3. You don't care what you are, Flashman. I turned it off for me, but I don't see it anymore. So I didn't know if it turned it off for the stream or not. And you just showed me that it didn't. But I only see it on your super chat. I don't see it on it for anybody else. That's weird. Flashman smells like number 2. Flashman.
Yeah, I'm right. Yeah.
Now he cares, Zach. Now he cares. All right, people. It's 10 o'clock.
And I just felt so natural and organic in that moment. I did tell him later because then he came to my office. I was like, you just threw that one up there. That one was just kind of fun.
Oh, did I? Hey, where's my closed captions? Somebody say something. I think I think that might be the woman that we hear. Maybe the one doing the hearing today. I don't know that though, because I can't see her. Nope. I am not doing Valo. She can go away just like Shanda is going away. Forever and ever and ever. I feel like we're eavesdropping.
They put her on Zoom yet, apparently.
Yeah, sure. I just keep, when she comes back in her next life, I just keep hoping that she just is in prison to keep serving her sentences. That's what I hope. Yes. What's up, Bree? How are you doing? Are you not figured you might be going with Super Sun? Not at 10:25? All right. Eating some breakfast. Bree said, I'm going to mute that for you guys for just a minute again. Bree said that Mad Dog's got like four teeth coming in at the top. Like, all at once. She's just doing everything all at once. It's crazy. We all said that would happen. What's up, Danny? How are you doing? Good morning to you. Come on, Shanda. I want to see her walk in. I want to see what she looks like after 2 years. I want to see if she's still going to be sporting the braids. I think she okay, I had to mute them. There we go. I can't talk and listen to them. So I think Shanda, she either thinks she's Laura Ingalls or Dorothy wear her hair like that. Pippi Longstocking. Who else wore some braids? Like, did she think that was going to make her look like, look at my two little innocent braids in my hair? Like, I am so innocent. Look at me. Like, well, we don't want to. But Tracy, wow, it just seems like yesterday she was in court with some horrible audio. Utah, the land of the crazy. I don't know. I might my state might be able to give you a run for the money for your money. She Gabby's already been censored. She walks in with the limp. Fingers crossed she walks in with the limp. Look at chocolate chip muffins and bananas with peanut butter. Oh, that's what I forgot to buy at the store today. It's Nutella. Dang it. I'll put it on my list. I'll get it Monday. I did get a couple bananas though, but I already ate one. Where's Adair? He better be getting his coffee ready. He's been complaining that we haven't been here in the morning and he hasn't been able to have coffee. He better be here. So for those of you, I guess, that are that are joining us that don't know what we're doing, doing the Shanda Vander Ark hearing for a new trial because she's dumb. And she was convicted of torturing and starving her son to death in December of 2023. He was 15. His name was Timothy. He weighed 69 pounds at the time of his passing. Everything was caught on her home cameras because she always watched Timothy with everything that he did, even going to the bathroom. So it was caught on video. We did not see it. We tried to hear it. So yesterday, there's a really long pause where you're just looking at the judge. Just fast forward through that if you're watching it on replay because we could not hear the video, which is fine. It's horrible. But it's her taking Timothy from an ice bath that he'd been in, I think, for 7 hours at that time, back to his small closet, which was a closet with a tarp in it, and laid him down there. He was gasping for breath. He wasn't really responsive to her because he was dying. So she ordered one of her dogs to lick his face to see if he would respond. And then she proceeded, he was gasping for air, so he's breathing through his mouth. So she proceeded to hold his mouth shut and tell him you don't need to breathe through your mouth, dummy. Awful person. Not to mention the times that his brother Paul, who's in prison currently as well, chased him up and down the stairs outside for punishment. They made him work in the garage and clean the garage with nothing from the waist down on. They made him do wall sits. They locked all the food away from him. They were horrible. He lived in a house of pure hell. And there was a younger child in there who they referred to as G that was fine. And they kept him away from all of this horror, which is good. I don't know where G is now. I don't know why the father wasn't involved in any, just called testify, because she was not even supposed to have Timothy. She was not. She was supposed to give up parental rights to him. Hey, Brandy Cat, how are you doing? Is there a bet going on how many braids she'll have today? I don't know. I hope we see her. I was like 4. That'd be hilarious. Hello, it's Britt. Yeah, I will never understand people like that. And I don't know how she watched him suffer and then pretended she didn't, like, was shocked he died. Like I don't know how she did that. Like, she was shocked he died. And then they lied and said that he went on a hunger strike after his stepfather had a stroke. Well, as soon as the stepfather moved, he had a stroke, so he couldn't stay in the house anymore. He was already in a wheelchair, so he couldn't get up and down the stairs of that house. He literally had to crawl. And that was her reasoning. She said that they put the cameras in. But he moved back home with his parents to recover and, whatever he needed to do after that. That is when, like, everything just amped up towards Timothy. And it's crazy. We have covered a few of these trials, and I'll never understand why it's one. I think it was Tammy said that's like called like the black sheep. I don't want to say syndrome. I can't think of the word, but it's like that one child that we have watched several of these horrific trials, but with crimes against children, and it's just one. I don't understand. If she has Pippi Longstocking going on today, I will I'll just have to be off. I will never stop laughing. So this is a hearing just to try to get her a new trial. I do not believe, there is no part of me that believes she will get a new trial. They are going to be basically, I think, focusing on her mental health at that time, her being catatonic, her being not competent to stand trial, not having effective counsel. Her old attorney is there, and this prosecutor said they may call him as a witness. And yeah, let's do it. Yeah, that's another sad story. The one there's 2, and they're both out of Texas, that stick with me the most is Mercedes. I always forget her name. LaSoya. Jose Ruiz was her mom's boyfriend. And I feel so bad. I can never remember his name. The little boy whose mom also beat the crap out of him. So bad. I mean, it was so bad. Him and Mercedes Timothy went through hell. Those kids, I'm telling you, went through it even worse. Like, this little boy, this big guy hits him and breaks his jaw, broke his leg, and you see him walking down the stairs in a sweatshirt and sweatpants in Texas in the summer. Like, they had him so covered. And then they drove his body to Colorado. And his mom said they gently lowered him down a mountain. No, they threw him over the side of a mountain, because when they found him, when she finally said where he was, the equipment they had to use to get down that mountain to get him was just awful. Yeah, she wasn't catatonic. That is horrible. There's been a lot of just really bad people in the news here lately, Flashman. It's just ridiculous. I mean, teachers, you're there to teach. You're not there to groom. Stop. It's gross. We have day after day. There's always a coach, a teacher, somebody, man, woman, doesn't matter. Every freaking day, that has done something with a child. I don't get it. Like, just stop. Come on, people. Yeah, Gabby, that video of him going, basically, like, that was horrible. Watching him try to go down the stairs, and then the kid wasn't going fast enough. Sorry, he had a broken leg, and the guy, like, jerks him. Oh my gosh. The prosecutor in the Jose Ruiz case, when she described what Mercedes went through, I think that was her name. It haunts me. Like, I feel so bad because the boyfriend took video of it and sent it to her mother, and she did nothing. Nothing. And she was made to, she had to hold her arms out with books. And this little girl was 5. And she didn't have books. I think she had jugs of water. And I mean, we're talking for hours that he did that. And there was a lot that kind of came out a little bit at a time where he probably was doing even worse things to her, taking pictures in really, really bad ways and sending them out to other people who are also sick and enjoy children in wrong ways. I don't know how else to say it. Sorry. Oh, they had, that one CPS worker like quit during that trial, or before that, during that investigation. There was like 3,000 pages of investigation on that family about those kids. And they didn't do anything. Oh, yeah. Bree, if anybody ever touched Mad Dog, I can't even imagine what that person would go through. I really can't. I just know the people in our family that are so protective, and wouldn't probably be a trial. Just saying. You know. What's up, Brandon? He always gives the wave. Hope your MRI goes well today. I hope they get some answers back to you soon so we can get that figured out. Also, I stole your Ethernet cord from downstairs. I'll put it back after today, but I'm just wondering if mine has an issue. We'll see. Everything went crazy last night. I'll tell you about it when I see it tomorrow. I know. Where's the heck Shanda? Like, it's 10:19. I told you they probably wouldn't start on time. When I came up here and I saw the court feed was on, I was like, gosh dang it, they better not start early. And then they're like, yeah, we'll just won't start at all. Oh, I know you would. I know you would. And it'd be one of those other things that just didn't exist. It is a scary world. And I think Flashman said it. This will not be the last trial like this. It will not be. It'll be another one. I don't understand. Like Steven Stearns, okay. He pled guilty, I guess. Fine, that's good. Don't put, I don't know the mom's, I don't know her, is she being connected anyway to what happened to her daughter? But at least he's not going to put the family through all the horrible things he did to her. But these other people, like Shanda, your crime is on your home cameras. You tried to get rid of it. You tried to get rid of the SD cards. You tried to hide it. She worked in that courthouse like that we're looking at right now as a clerk for a judge. Like, you had help available and you chose not to take it because you knew probably you'd get in trouble because you weren't even supposed to have Timothy at your house. You were allowed 3 hours per month of supervised visitation. So she knew. Like a hospital or like a mental health hospital. Hey June, how you doing? Good morning to you. I keep meaning to ask you what kind of dog is in your picture. Because he's very cool looking, or she. I know they have flash fan, and it sucks. And there's so many that we never hear about. Like, isn't it that I always look at it like, what kind of dog is that? I have you can't see, but I have my I usually close the door to keep my dogs out, but they're like, what are you doing? What are you doing? Are you get like they've just been clingy for the last couple of days. So I left the door open. They came in and they left. So if they come in and start getting, I'm sure like as soon as everything starts, they'll be like, oh, we're here. So if they get annoying, I'll shut the door again. I'm surprised Rue's not just laying right outside where I can see her. No, she is not. They are not. That's so funny because I got up, I went grocery shopping, picked up my Walmart order, came home, was like putting everything away, and they're just like looking at me like, what are you doing? I gotta hurry. It's a rat terrier. His name is Maximo. He's your service dog. In the picture, he is 6 weeks. Aw. And just picked him up to go home for the first time. Aw. That's sweet. He looks very happy. You look very happy. Dogs are the best. Sometimes they can be a little, sometimes they're like children. Flashman, stop trying to give away your sister's dog. That's not yours. Also, my dogs and your dogs, there's a huge size difference and it wouldn't work. It wouldn't work. I keep hoping when there's the prosecutor. You were about to. Oh, that means something happened. I don't like. I'm sorry. Oh my gosh, you have no. Well, you do have an idea, Tracy. You go nowhere alone. Nowhere. I was walking upstairs last night. I had a basket full of towels. I had my laptop on top of the towels. I had my phone in my hand because I know this will surprise Gabby, but I was talking to Carmen, and my youngest thing, she wanted to get upstairs before me for whatever reason. She came running by me, hit that basket. I caught everything. I was like, and then I was like, are you serious right now? And she got to the top of the stairs and she just turned around and she just looked at me like, oh, I'm so sorry. But now I'm like, I need you to move so I can get past you in the top of the stairs. Uh-oh. Court insiders. Attorneys just went into chambers in Vander Ark. Not a great sign. What? What is happening? You did graduate. Is that? I'm not like, sorry. I always get the letters. I know that's your bachelor's. It's like your associates in 2020 and 2022. I'm probably saying it wrong. Sorry if I am, but congratulations on doing it. My dogs are not 200 pounds. Not. They're probably about 150 pounds. We had one named Duke. He thought he was the size of the Great Danes. Arts. Thanks, Brandon. I knew you'd come in and save me. He's probably just going, Mom, stop talking. He'll tell me tomorrow. He'll tell me about it tomorrow. Associates of Arts. I'm sorry. I was going to guess that, but then I thought maybe I shouldn't say that. Maybe it's not that. Maybe it's something else. You had a beta fish that your sister named Peanut Carl Sanderson when she was little. No. I am streaming and I'm getting in the pool, and I will tell you right now, I have a cooler. It's full and it's got ice in it, and it's going outside with me. Oh my gosh. Look who it is. George, how are you? I miss you. You have to come visit more. I know you're still awake at night when I'm streaming. Must have heard like, did you hear it was my birthday Sunday? Is that why you're here? Man, come visit us more. I miss you. And see, I haven't been called Linda in forever. That's all right, George. I'm just telling you, you have to be here. You have to be here. My husband said to me yesterday, he goes, he was joking. He said, "So you get called Linda Carter one time, and that's just how you're going to wear your hair forever." And I said, "Would you like me to go buy you a wig with the length of my hair, and you go outside?" And he's like, "No." What is up, Jess? How are you? We're waiting for Shanda, but they just said that they're in judges' chambers, and that wasn't a good sign that the attorneys are in there. I don't know if she's in there or not. So I don't know what's going to happen. We may just be sitting here for nothing. Nothing. Which I would be sad. Hey, Courtney. How are you today? Hope you're having a good day so far. It's Friday. Yay. It's a party for Linda. Yeah, it is. Oops. Hey, Tink. How are you? Good to see you. I keep trying to click on that. It is, yeah, it's hot here. It is hot here too. And so humid. You just walk outside and like, I laughed last night. Thank you, George. Can't always be your clamp. Dang it, I thought we both were. Man, I fell out of status. Darn it. It took because Gabby's like, "Do you wake up with your hair like that?" Not fun. I took it down yesterday, and it was like poof. I was like, It was so funny. I just looked at myself. I'm like, man, the 80s came. It's like I have a feeling you might be right, but I don't. What would she be doing? Like withdrawing her motion? It is always. It's always the corn's fault. Yesterday, I told Gabby I'm going to send people into the cornfield if they don't behave. Jess says corn sweat is the issue with the weather. Well, I am surrounded by a cornfield, so must be. Why are we moving? Is that why I'm so hot? Because I'm surrounded by corn sweat. What the corn? Yes, that's what mine did. I took it down. Oh, I put it up. It was kind of wet yesterday when I put it up. So when I took it down, it it just made me laugh. I was like, oh my gosh. Oh, you did. Okay. Well, I don't know if the children of the corn are there. Have you ever seen the Twilight Zone episode where the little kid he like runs the whole town and he can make it snow in the summer, and if anybody gets mad or if anybody makes him mad like over the littlest slightest thing, he sends them into the cornfield. That's so we have uh that's kind of a joke in our family, like we'll, or at least between my husband and I, will be like, I'm gonna send you into the cornfield. We also ask, if you've watched Shining ever, the original one from the early, I think from 83, in the bathroom scene with Grady, the caretaker, and Jack Nicholson, well, Jack, Grady talks about correcting his children. And then when his wife got mad, Jack said, "What did you do?" And he's like, "Well, I corrected her too." Something along that line. So that's a joke too. I'll ask my husband, like, he's having a problem with, like, especially if it's a woman at work, I'll be like, "Did you correct her?" You sent me a video. I got to see in Discord. I got to see. Oh man, I'm in the wrong Discord. Can I play that without getting in trouble? I don't know if I can play it without having a TikTok account. I know. Everybody's like, Gabby, I have gone over and visited Wolf's chat, and I have even said hi to George, and he said nothing. Nothing. So I left. I always like her pictures. I'm just excited about everything she's done this week, like, and her teeth. I am not on TikTok. That's why I can't play TikTok videos. It won't let me. What? I keep going at the wrong time. So he's there. He's chatting. I say hi. He says nothing. Oh, I can't wait to see it for you. I'm excited. All right, let me see if I can open this. I don't know what's happening. Now I'm buffering. What would AJ TikTok be? Come on. Next time, wave my hands. I'll get his attention. I will. Don't you worry. Where you at? There you are. Okay. Do I have to? All right. Stop. Let me see here. Give me a sec. This is me learning something on the fly. I'm scared. Oh, no, don't want this. There it is. All right, Jess, if I do it like this, am I going to be okay? Proceedings are delayed as the court struggles to get Vander Ark's remote feed up. So she is not going to be there. I have no words. Okay. All right. Let me back it up. Let me know if I need to turn it up. Or down. You can't hear it at all? That's perfect. Why? Dang it. I have it. Oh, why can't you guys hear it? Hang on. It was fun. It was great. Thanks. Why won't it play that? I thought. Oh, wait. Oh, they just had her up there. Why is that not? It doesn't. When I am, when I try to click to share the audio, it doesn't, where it says to share the audio is grayed out and I can't click it. Thanks, Gabby. Video file. It's that one. Nope. I've never tried to share. Yeah, can I share it in Discord? Because I'm dumb. Wait. I might have it. Hang on. Let me see if this works. All right, let me know.
This is a public service announcement. Please share this information widely. There is going to be a massive heat wave that's going to start today and intensify throughout the week through much of central United States, as well as towards the East Coast near the end of the week. A lot of this has to do with the fact that there is corn sweat going on. That's a process where the corn crops are releasing a lot of moisture into the air in a process called evapotranspiration, and that's going to increase the relative humidity, making it harder for people to have evaporative cooling. So when you sweat, that helps cool down your body when the evaporation occurs. But since humidity is high,
Wait, so since I live, there's corn all around me. I'm not kidding. When I go down my driveway, there's a huge cornfield. So when I sweat, is it like going into the cornfield? Like the corn's not going to let it go anywhere? What's happening? Who is this guy? Hey, Brandon, where you been? I didn't think that was funny anymore. Will you stop showing up? But I don't know why your organs are failing. Okay, this is crazy. This is crazy. Okay.
it's going to make the real field temperature be as high as about 115 degrees Fahrenheit by about Wednesday and Thursday in many states, including Illinois, Indiana, Iowa, Missouri, Minnesota, and the Dakotas. Please make sure that you are checking in on your local weather reports to see when this is going to affect you and to stay as cool as possible. Be indoors, keep the AC running. If you are outside, hydrate as much as possible.
All right, we've not been 115 here. We have not. It's been a feel like 100, but it's not been a feel like 115 here. This is hilarious. Oh, Brandon, I'm sorry. I hope your organs really aren't failing. Get better and stop that. I want good news from you, Brandon. Good news and bad jokes. Well, Arizona should be like, that should be their temperature, 115. And then the heat index on top of that. We're not there. Yes, the damn corn. Damn you, corn. Yes, Brandon, blame the corn sweat. I have never heard this. It's ridiculous. I'm going to go out and touch the piece of corn, see the leaf, and see if it's sweating.
To cool down, make sure you're taking cold showers and have wet towels, and check in on vulnerable populations such as children, the elderly, pregnant women, people with chronic health issues such as cardiovascular, respiratory diseases. People with allergies and asthma are going to have a worse time too, because a lot of the allergen triggers are going to linger in the air more because that humidity is going to be high. Also, if you're experiencing headaches, dizziness, confusion, feeling weak, make sure that you go indoors as quickly as possible. You may be having signs of heat exhaustion or heat stroke, especially if you're taking certain medications like specific antidepressants like SSRIs, but there are several medications that could make it harder for your body to regulate temperature. So please share this post with as many people as possible so that we're all aware of what to do.
Oh no, I have medications on that list. Hey, Holly's mom. Oh geez, I have sweat in places we dare not mention. I'm with you, girl. I'm with you. Oh, too big of a fight. I'm just going to sit this one out and rub corn all over myself. Please take video, but only if you have your clothes on. If you hear the corn pop and run. What is this guy's name? Ruben Allergy? What? Okay, it's almost over.
During this potentially very hot week.
Okay. Well, Go away. Goodbye video is like some weird Midwestern prawn. I like it. You'll bring them butter. I'm sorry. He's probably really good. I've never seen his videos. No, Shanda's not in court yet. It was funny. It's just funny because I live all around corn. Oops, I didn't mean to put him back. Go away. And plus, I don't have TikTok because I don't. People send. I know I need it. Just sounds funny. Yeah. So see, blame the corn. I'm gonna tell my daughter-in-law that I don't even blame the corn. She got some weird stuff happen when she moved up here, and with her breathing, I was like, blame the corn. They generally alternate between corn and soybeans, the fields every year, but then sometimes they don't. I don't get it. But whatever, it's their stuff. He grew up with Children of Corn. Me too. And the original Children of Corn was, took place in Nebraska. That's my home state. And I lived there when that came out. And I was a little kid. And boy, did we like to scare ourselves with that movie. And we'd always be like, he wants you to, Malachi. It's so dumb. I did not grow up watching John Wayne, but my brother watches John Wayne. Yeah, I probably. It's just kind of funny because they plant like corn in one field. So I'm always excited the next year they're going to plant soybeans in that field because it's at the end of the road and you can't see around the corn to turn onto the next road. Like, plant beans here, please. It's corn this year. I think so. Feels like it's corn again. But no, we got a judge.
Morning.
There she is. No braids.
Before the court is file 23110FC. It's People State of Michigan versus Shanda Vander Ark. Are you Shanda Vander Ark?
Yes.
All right, Mr. Vander Ark, Ms. Vander Ark, can you hear and understand me okay?
Yes, I can.
All right. Ms. Vander Ark, we had confirmed through your counsel that you wish to appear at this hearing via Zoom today. Is that still your desire?
For this hearing.
For this hearing. Okay. All right. Mr. Ambrose is here on behalf of the defendant, Ms. Vander Ark. Mr. Roberts, as well as Ms. Bloomquist, is here on behalf of the people of the state of Michigan. Date and time scheduled for a hearing on plaintiff's motion for a new trial or evidentiary hearing. Or excuse me, defendant appellant's motion for a new trial or evidentiary hearing. The court has read the motion, the attached brief, as well as the plaintiff's response and brief in opposition to that evidentiary hearing, including the attachments. Was there anything else that was submitted, either Mr. Ambrose or Ms. Bloomquist, that I don't have?
I have not submitted it.
Okay, Ms. Bloomquist?
No, Your Honor.
Okay, Mr. Ambrose, at this point in time, you want to just make some argument? You can call witnesses. I'll leave it to you at this point.
The testimony is going to be baked in. I would prefer that I have my client with me in person. That's our preference in this type of setting. Typically, on a motion like this, if the court grants any type of evidentiary hearing, that would be great. And then we could have Ms. Vander Ark in person with us.
Okay.
But other than that, you know, I did write a pretty detailed brief in this case, raising two primary issues. One is whether or not Ms. Vander Ark was confident after giving her first day of testimony. She had a medical issue. She was in some sort of distress. Coming back the next day, it seemed pretty, from the transcript at least, that she had undergone a significant downturn in her mental health. That it was described by her trial counsel that she was not competent to go forward. I think there was about a 2-hour delay. There was some sort of discussion with Ms. Vander Ark. There was that she wanted to hurt herself. All of these factors are pretty consistent with the case that I cited, seminal cases, Droke versus Missouri. And if you look at that case and Ms. Vander Ark's situation, they pretty much fall in line. So, you know, if the bottom line is, well, was there a bona fide doubt as to her competence? And if there was, then the way to go about things is suspend the trial, have her checked out, and then if there is no longer an issue there, then proceed with the trial. And that's consistent with what Droke says, but it wasn't done in this case. And if there is additional testimony taken on this issue alone, like I said, I would like to have Ms. Vander Ark here for that. The second issue, Your Honor, is ineffective assistance of counsel. I laid out a number of areas that I feel that there were some missteps in that Ms. Vander Ark was not provided her Sixth Amendment right to the effective assistance of counsel. And we do start off again with the competency issue of not requesting
The heck?
not requesting her to be evaluated. And so that was one issue. Another issue that we raised is Ms. Vander Ark testified at the time of trial. She's always remained consistent about her innocence. And
I think so.
trial counsel, during his closing argument, made a statement to the jury that she was guilty of manslaughter. Well, my client never consented to that type of argument, never consented to a lesser included offense. So that's a second issue that we have raised, and is ineffective assistance of counsel. I made a number of other areas that we felt that trial counsel was ineffective, and one was on the death certificate. The first thing that is noted is dehydration. And in this case, there was many allegations about Ms. Vander Ark restricting food to her son. But there was never any type of allegation about restrictions of water or liquids or fluids. And if you do any type of research in this area, you know, a person knows that they will die within days if they don't have any type of water. But a person can literally last weeks, sometimes months without food. And so with dehydration as being the first statement in the death certificate, I think it was important to highlight that as a trial counsel, because that is what's the first statement. And I think in my reading of the transcript, there was only one question about that by trial counsel. I think the main focus in the case could have been or should have been that the real cause of death was dehydration, because there was never any type of restriction on water. But like I said, Your Honor, I have outlined a detailed brief in I'd be willing to answer any questions that you might have.
All right, real briefly, I just want to make sure that the court understands the argument regarding the competency. The claim is, my understanding based on the brief, is that the competency or the incompetency, alleged incompetency, occurred not during the whole or parts the whole trial, but simply at that moment when she was done with questioning at the end of the day. I think it was on the 14th. I think it was Thursday. Is that correct?
That is correct.
So there's no allegation that she was incompetent at any other point during the trial except for the moment she was done questioning. The court, I think, was going to break for the day or something like that. Correct?
That's the pivotal portion of the case.
Okay.
Because she goes through, and granted, prosecutor did his job. I mean, he was tough on her, and that's his job, and I can appreciate it, but it had a significant impact. Apparently, my understanding is that she was pretty much paralyzed, and couldn't move, and couldn't function the following day.
Okay. All right. That's all the questions I have at this
Thank
point.
you.
So, yep. Thank you, Ms. Bloomquist.
Only after cross, she was traumatized, catatonic, incompetent then
Well,
after.
it's the people's position, Your Honor, that the defendant's not entitled to a new trial because she was not denied a fair trial on the bases raised at her motion for new trial. Specifically, her issue 1, dealing with competency. The test for this is there's a presumption by statute that a defendant is competent to stand trial, and that is MCL 333.2020 subsection 1. And the test that this court is supposed to apply, or the test that would be applied on an appellate basis of this court's decision not to hold a hearing, is that when facts and circumstances are brought to the court's attention, or that the court itself observes, raises a bona fide doubt as to the defendant's competency. That's when a hearing on a defendant's competency should be held. It's our position that in light of the facts before this court, the facts in the record, and the facts known to all parties involved, that there was not a bona fide doubt as to the defendant's competency. And our appellate courts have set forth certain considerations for a trial court when it was situated as you were to make this decision. The court can look to the defendant's irrational behavior, the defendant's demeanor, and prior medical records related to competency. And I guess the main crux of this, Mets People versus Camarad 307 mishap, Your Honor, there was never anything in any of those 3 components that are factors for this court's consideration that would support that the defendant was in fact incompetent to undercut that presumption of competency. In fact, I would assert that the record before the court is that this was a feigned bout of incompetence to harbor an appellate parachute to undermine a jury verdict. And I think the court also is well aware that Ms. Vander Ark is a trained individual who might not be an attorney, but she went to law school, and by her own account, she was very smart, passed bar, has all sorts of knowledge on certain things that she could do to undermine a jury verdict in this case. And People versus Camarad specifically says that if the defendant's actions are purposeful and are more or less a strategic game, it is not an expression of mental illness or a denial of reality, and it would be proper for the court to not find a bona fide doubt as to her competency. So turning to the facts in the record, Your Honor sat here and watched Ms. Vander Ark during the days preceding this alleged incompetency. She was present at counsel table mere feet from Your Honor. She testified before Your Honor. You were able to see her interactions with her counsel, with individuals that were part of her defense team, as well as to hear her testify. Nothing in what happened in the days leading up to this incompetency would support that there was a bona fide doubt as to her ability to be a part of her defense team. Further, I think with that, what's very relevant and highly probative to this question is there was a pleading almost identical to this that was filed on a motion to quash bind over to send this case back to district court, where Ms. Vander Ark alleged that during her preliminary examination, she disassociated and she was unable to be present because of this condition at her preliminary examination. She raised these same issues as to competency. The motion to quash was presented to this court, and my understanding from that is that the court was able to review her competency evaluation that was done by the Center for Forensic Psychiatry here in the state of Michigan. And as that report indicates, the court would bear with me a moment. As that report indicates, the defendant had a, quote, sophisticated understanding of the roles of the various court participants, her defense options and possible outcomes, and clearly voiced her willingness to engage and rationally assist her attorney in this matter. And then the clinician went on to say, I did not observe any behavior indicative of an intellectual disability or other cognitive, physical, or psychiatric issues that would impede her adjudicative competencies. Your Honor, the court can absolutely consider all of that in making this determination as it relates to the defendant's competency. And I think that the record supports that this court made the proper determination that she had not overcome the presumption that she's competent, and in fact, not holding a hearing was the right decision on this matter. Now, to succeed on a motion for new trial, the defendant would have to show that there's a basis for appellate relief. And looking at your decision and this court's decision, there is not a basis for appellate relief on this issue. Now, I do know, I am prepared today to take additional testimony should the court require it on this specific issue in the form of individuals who saw her during this claimed incompetency who would be here to testify as to their observations of her outside of what the court itself observed in making this decision. And so I'd be prepared to do that today as it relates to issue one. But ultimately, Your Honor, there is no basis for a new trial as it relates to her feigned or malingering incompetency that's been presented today. Turning to issue two, as the court's well aware, the burden's on the defendant to prove that she was denied the effective assistance of counsel. And that burden's twofold. First, she has to show that there was deficient performance, and she has to show prejudice. And I'm going to be a little bit out of order here, Your Honor, because she has to prove both. She has to prove both prongs. And in light of the overwhelming evidence that was presented about this defendant's culpability and her guilt in what happened with her son, it's my position that she can never establish that any of these claimed instances of deficient performance, which I don't agree are deficient performance, but for the sake of argument, if you were to assume they were, she could never overcome that second necessary requirement of showing that any of Mr. Johnson's actions prejudiced her in light of the overwhelming evidence supporting her guilt. And I do have all of my responses to the prong one as it relates to those, as it relates to the individual claims of deficient performance. But Your Honor, I don't believe that the defendant can ever meet that Strickland standard and show that she was denied the effective assistance of counsel. I would note, however, like I said, for issue one, I do have Mr. Johnson here, who, as well as another individual from his office, who would be willing and able to testify if the court were to order again their hearing. And I'd be happy to answer any questions the court might have.
All right. No, I don't have any questions at this time.
Thank you.
Mr. Ambrose, I'll give you a chance to briefly respond if you wish to.
I would say.
Okay. All right. All right. Well, as indicated by both attorneys, the court always starts with a presumption that's under MCL 330.2020 that a defendant of criminal charge is presumed to be competent to stand trial. That statute indicates he shall be determined incompetent to stand trial only if he is incapable because of his mental condition of understanding the nature and object of the proceedings against him, of assisting in his defense in a rational manner. There's case law that also indicates that, quote, a criminal defendant's mental condition at the time of trial must be such as to assure that he understands the charges against him or her and can knowingly assist in his defense. The court, obviously the parties know under court rule, either the parties or the court sua sponte has the ability to address the defendant's competency at any point in time in the trial proceedings. The trial court, specifically me, has the duty to raise the issue of competency where facts are brought to the court's attention, which raise a bona fide doubt, that's in quotes, as the defendant's competence. That's specifically a quote from People v. Harris, 185 Mich. App 100. That is actually cited in the Cameron case. The Mr. Ambrose cites the two primary cases. It's People versus Camerad, 307 Mich. App 98, and the federal case of Droke versus Missouri, 420 U.S. 162, a Supreme Court case. So essentially, the question for the court is, did the court have facts in its attention that raise a bona fide doubt as to the defendant's competence? Essentially, the court is focusing on the morning, the 15th, I think it was December 15th of 2023. So the analysis, and also People v. Cameron says the test for such a bona fide doubt is whether a reasonable judge situated as the trial court judge should have experienced doubt with respect to competency to stand trial. Evidence of a defendant's irrational behavior, a defendant's demeanor, and a defendant's prior medical record relative to competence are all relevant in determining whether further inquiry in regard to competency is required. That is a cite from People versus Camerad, which also cites the Droke case. So the court begins its analysis in terms of what I, as a trial court, knew or understood, or at least had experienced regard to Ms. Vander Ark's competency or alleged incompetency, what her behavior was. This court, even prior to trial beginning, had reviewed Ms. Vander Ark's competency evaluation, which is referenced by Ms. Bloomquist. And the court also had an opportunity to review the preliminary hearing transcript. In normal circumstances, the trial court, my practice is not to review those things in case it's a bench trial, and then the court needs to remain impartial. However, at the stage prior to trial, as Ms. Bloomquist indicated, Mr. Johnson had filed a motion to quash the bind over, or at least remand for preliminary examination, because of incompetency that had occurred or allegedly had occurred during the preliminary examination. The court's review of the preliminary hearing transcript indicated that at some point during the preliminary examination, Ms. Vander Ark had allegedly experienced some distress. I think it was described as maybe a panic attack, and that Mr. Johnson had asked for a brief recess to allow Ms. Vander Ark to compose herself. Judge Maria Lattice Hoops in the 6th Year District Court was in a unique position at that point to observe the defendant and her behavior, and indicated that she, I think it was almost a quote, that she looks fine, and she proceeded forward. So another court sitting, presiding over a hearing at the time that one of these alleged panic attacks occurred, observed the defendant's behavior, made a determination that she was competent to continue forward. I think it's also important to note the panic attack that occurred in district court occurred not randomly, but after her co-defendant, Paul Ferguson, took the stand, which is seems to be rather convenient. But again, the court also looks to the judgment of the district court, who had a chance to observe this panic attack and made a determination that they would move forward. The competency report gives no indication that Ms. Vander Ark was incompetent. Just for purposes of the record, the competency report was dated November 16th of 2022. The preliminary hearing actually occurred on January 4th of 2023, and that the competency evaluation indicates in several instances that she was competent. Specifically, there's this is page 3, a quote from the competency report that says, during the interview, Ms. Vander Ark was alert and oriented to place, person, and context. She demonstrated an ability to retain, mentally manipulate verbal information, to remember multiple items after several minutes, and displayed a sound reality testing and good judgment with regard to hypothetical situations. Ms. Vander Ark's memory was good with respect to ability to recall relevant details of her background, history, and activities around the time surrounding the alleged incident offense. Her cognitive abilities are estimated to be at least within average range, as evidenced by her education and performance with respect to above listed capacities. This estimate is supported by her self-reported academic and employment history, as well as her conversation style, vocabulary, and ability to reason throughout this interview, end quote. Later on, there's a list in this report of her understanding of the nature and object of proceedings against her. I don't want to read the whole thing, but clearly she understands exactly what's going on, the understanding of the roles of courtroom personnel, her involvement, her in her defense, her counsel's responsibilities, the prosecutor's responsibilities. Ultimately, under the section labeled competency to stand trial opinion, the examiner indicates in quotes, "I did not observe any behavior indicative of intellectual disability or other cognitive, psychological, psychiatric issues that would impede her adjudicative competence." It says, "In my opinion, Ms. Vander Ark was aware of the charges against her, how they came about, and provided a consistent version of how events unfolded from her perspective. She considered her defense options as reasonable expectations and appeared legally knowledgeable. In my opinion, Ms. Vander Ark demonstrated sophisticated understanding of roles of various court participants, her defense options, and possible outcomes, and clearly voiced her willingness to engage and rationally assist her attorney in this matter. In my opinion, Ms. Vander Ark was able to understand the nature and object of proceedings against her and to rationally assist in her defense. Therefore, in my opinion, she is competent to stand trial." Just because, obviously, I'm sure defense would argue that just because she's competent in one moment doesn't mean she doesn't become competent in another moment, but that's certainly something the court had reviewed prior to my interaction with Ms. Vander Ark up in circuit court. Then the court had a chance to observe Ms. Vander Ark at trial. Ms. Vander Ark appeared to be calm, collected. She interacted with her trial counsel, Mr. Johnson. She appeared to be writing notes, handing those notes. She interacted with Mr. Goings, her co-counsel, along with Mr. Johnson, and she at least appeared to be very involved in her defense. The court has presided over several trials, and Ms. Vander Ark appeared to be more involved than many defendants are. Typically, defendants say a few things and they kind of leave it up to their attorney. Ms. Vander Ark was practically appeared to be a co-counsel sitting at a table. The first indication of any distress on Ms. Vander Ark's part didn't occur at any part of the trial, even when her co-defendant, Mr. Ferguson, was testifying. During all the other witnesses that potentially testified, the first incident that could be considered potentially an issue or concern for the court occurred during the last day of trial on the 14th. Mr. Roberts was cross-examining her, and just to be clear for the record, the court has not only reviewed the trial transcript, the court actually rewatched the entire trial. Because you do not get the same feeling for Ms. Vander Ark. You can't get it from the transcript because there's no indication of how she's acting when other witnesses are testifying. We have the fortunate ability to have cameras basically focused on the defense table, prosecution table. So the court was able to observe Ms. Vander Ark's demeanor throughout the trial. But specifically going back to December 14th, Mr. Roberts showed a picture of the deceased Timothy to Ms. Vander Ark, and she had this episode of vomit. That occurred at approximately 3:51 and 36 seconds on December 14th. Everything calmed down, even apparently after that, and we resumed testimony only 10 minutes later. So being confronted with even if for argument, Ms. Vander Ark is completely innocent of these charges, to see her son in that manner certainly, brings out a vomiting issue, but she's just ready to go after 10 minutes. Completely fine. And then Mr. Roberts continues to cross-examine her until 4:48 and 11 seconds. Mr. Johnson then redirects her, does redirect until 4:51, and Mr. Roberts again recrosses her until 4:52. And during that whole period of time, again, she appears to be calm, cool, collected. She doesn't appear to be crying and appears fine, doesn't appear to be suffering for any mental distress. And then 8 minutes later, as the court is discussing jury questions with the attorneys in a sidebar, there's a mental distress 8 minutes after any questioning is concluded. So that was what the court had a chance to observe that day. The court didn't receive any information from the jail staff or counsel or anybody that she was suffering any distress. After that, the court broke for the day and then resumed in the morning on the 15th. At that point in time, the court was going to start at 9 a.m. And Mr. Johnson indicated to the court, I think it was in chambers with Mr. Roberts present, that they were having some issues with Ms. Vander Ark's ability to come to court. It's unfortunate that these things were not placed on the record, but not specifically remembering everything, but the impression was for the court was that Ms. Vander Ark was suffering some mental distress, was upset, was crying, but it was never brought to the court's attention that she could be incompetent. Now, I did have a chance to review the transcript. Mr. Johnson refers to the competency of his client. And in the context of everything that's going on, the court finds that not to be an expression of competency to stand trial, but competency in terms of her mental health is such that she's in a upset state. There was no other indication that potentially Ms. Vander Ark was incompetent to stand trial. The court waited 2 hours. It was then discussed with the court that she was going to waive her right to appear in person. And the court obtained a written waiver from Ms. Vander Ark, indicating that she did not wish to appear. The argument being made at the time now is that Ms. Vander Ark, at least according to her affidavit that was attached to the brief filed by her counsel, was that she does not recall signing that. And, throughout the trial, Ms. Vander Ark claimed lapses of memory, but it was clear to this court that those lapses of memory were self-serving and that her ability not to remember things occurred during periods that she could be either criminally culpable or at least the things that she had said would hurt her defense. So her allegation now that she does not remember that is rather convenient, that the one component that she does not remember when she was in the jail was signing a waiver to appear. Her affidavit indicates that she was aware of other things that morning, but she's not aware of that. So based on all that, what the court had an opportunity to observe, I will indicate this. Mr. Ambrose indicated that these facts are like Drope. The Drope case involved a report from a psychiatrist that was given to the court regarding the client's mental health status, and which raised a doubt that the psychiatrist had recommended that the defendant in that case undergo a mental health evaluation or competency evaluation. That we don't have that here. We don't have a psychiatrist that gave a report. Defense counsel didn't give a report to the court or say there's a concern, or we got a report from somebody indicating that she needs to be undergo a competency evaluation. We don't have that here. What we have is the court's observations. A lot of these panic attacks seem to occur in moments where there could be some critical or really prejudicial information that potentially is coming in at the time of trial or prelim. They don't seem to be random. They seem to be calculated. So the court, based on all those things the court had observed, the question for the court is, whether the information for this court raise a bona fide doubt as to her competency, or that she should be undergo a competency evaluation. And the court says that my ruling is that a reasonable judge sitting as what I was looking at would not have a bona fide doubt, that it was, at least according to this court, was clear that she was competent. Now, was she suffering some distress? Yes. In most trials, cross-examination is very stressful. Mr. Robinson is a seasoned trial attorney. He engaged in very good cross-examination, very pointed. That is upsetting to most witnesses. And I have no doubt in my mind that Ms. Vander Ark was upset and potentially didn't want to come to court to face more of the cross-examination. But there's nothing that was before this court at that time that raised a bona fide doubt as to her competency to this court. Now, as to the issue of actual competency, whether or not she was competent, again, there's two standards. One, should the court have held a competency hearing? That's based on whether or not the court had a bona fide doubt as to her competency. So the court finds that it did not have a bona fide doubt as to her competency. The fact that the question is, was she competent? Again, there's the hearing, and then there's whether or not she was competent. Now, Mr. Ambrose, in chambers, we talked about potentially taking testimony as to Mr. Johnson's observations of Ms. Vander Ark, as well as any other caseworkers that met with her. This court finds that I have enough information in front of me to make a ruling today. However, I will reserve the opportunity for Mr. Ambrose to call witnesses, or the prosecution to call those witnesses. But I am going to make a ruling on that issue today without prejudice, so the court can hear additional testimony. Mr. Ambrose has requested that if that testimony occurs, that he would like his client here. I don't have an objection to that. Having previous history as a defense attorney, the advantages of having your client right next to you during cross-examination or during examination are incredibly important. So he said, if we're going to have testimony today, and I think his client has expressed that she would like to be here, I don't have any objection to that occurring. And so likely that will leave us in a position where we'll have to have a hearing at a later date where Ms. Vander Ark will be present. However, in terms of the court's finding of competency, Ms. Vander Ark attached an affidavit to the brief filed by her attorney. And I think a portion of that is very telling in terms of her competency. Specifically, I think it's page 11, last paragraph. She indicates, I testified for around 5 hours on the Thursday of trial, was supposed to finish my testimony on Friday, including some very important questions that I wanted Mr. Johnson to ask me before I finished testifying. However, I had a severe mental breakdown on Friday morning. I had several panic attacks and was completely paralyzed, unable to even make it to the elevator to go to court. I curled up into a ball and was barely able to communicate. During this time, I specifically asked Mr. Johnson to postpone the trial until I was able to participate. When I asked this, he said there was no point in delaying anything. He stated that they could continue without me. I never agreed to waive being in court for the rest of the trial. If there is a document with my signature on it, I do not recall signing it. Further, I was in no condition to agree to proceed without my presence. The standard for competency to stand trial is different than potentially just being unable to move or being unable to talk. What competency is essentially is, do you understand the object of the nature of the proceedings against you? And do you have the ability to assist in your defense in a rational manner? Ms. Vander Ark's indicating in this affidavit, indicating that she knew there was trial going on that day. She also indicates she had very important questions that she wanted Mr. Johnson to ask. She understands that Mr. Johnson's his attorney, that he asks questions. She's apparently of enough sound mind to form important questions for him to ask. She also understands that, that she has to delay the trial. So she's aware there's a trial going on. So, looking at those things, when you go to the competency element, again, it shows the court that she has an understanding of her attorney, the prosecutor, the trial, those things that are going on. But she wanted to proceed with her presence. The court is not held slave to somebody's being upset that they don't want to go to court. The test is competency to stand trial. Are you competent to stand trial? Not that, well, I'm crying and I'm just really panicked and I'm in, that's not the standard for the court. Now the courts give a lot of discretion to allow a defendant time to calm down, or witnesses to calm down, to see if they can proceed. This court allowed Ms. Vander Ark 2 hours in the morning. And it was then, and quite frankly, there was no threat to Mr. Johnson, or not much of a threat, but there was no indication that, well, Mr. Johnson, we got to get rolling right now. We got to go. It was Mr. Johnson, her counsel, that said she wants to waive her appearance here and wants to go forward with me representing. And based on the court's finding that she was competent at that time, her appearance, her lack of appearance was voluntary. She voluntarily did not want to appear, and that's evidenced by her written waiver. And again, she's saying, I don't remember that. Court finds that to be self-serving. She doesn't remember something that could hurt her defense legally. Specifically, People versus Swan 394, Mish 451 indicates, quote, a defendant's voluntary absence from the courtroom after trial has begun waives his right to be present and does not preclude the trial judge from proceeding with the trial to conclusion. There is, at least in the court's estimation, there was a valid waiver signed by a competent, legally competent person. That was the court's, that's the defense voluntary absence. She chose not to be here. The court proceeded without her. Even in absence of a waiver, the test for determining whether a defendant's absence from a part of trial requires reversal of his or her conviction is whether there is any reasonable possibility of prejudice. So the other question is, even if Ms. Vander Ark had not waived her right to be there, and even if she potentially, I don't want to say incompetent, but the fact that she was not there, the court looks at the prejudice component. The trial was concluded. The only thing left was jury questions and closing argument, deliberations. That was it. And so based on that, the court finds the possibility of prejudice was minimal. The court explained the absence of the defendant to the jury, said that she was suffering from medical distress. She wasn't an order for her not to appear. She didn't do anything wrong, essentially, but she was not going to be here. And so the court finds that there was no prejudice to her not being here. Now, the other interesting thing that the court last night reviewed the video again, there was this question of, well, there was questions that want to be posed to her. The traditional examination stage is essentially direct examination, cross-examination, redirect, recross. That all had occurred, and it went back to redirect after Mr. Roberts had recrossed, and Mr. Johnson essentially said, we're done with our questions. The only thing that was left was jury questions. Jury questions are in the discretion of the trial court. There is no right by a defendant to have a jury question or offer her questions. So essentially, the component that was, even if she is not here, the component that she gave up was presence for jury questions, which may or may not have been admissible, may or may not have even been able to have been asked her. And it's something that was not a right of the defendant to have a jury ask her questions. All the things that typically come into a trial occurred, and the defense was done asking her questions. So there is no guarantee at all that she would have been asked any more questions whatsoever. And she didn't have a right to have those questions posed to her, although it was the practice of the court. So all those things, the court is finding that she was competent. It does not warrant a new trial in this case. There was no bona fide doubt that she was not competent to stand trial the morning of. So with the reservation that I've already made in terms of additional testimony from Mr. Johnson or other caseworker, which needs to be called at this point in time, the court is making the ruling that the motion for a new trial based on incompetency is denied. In regards to the basis for relief off of ineffective assistance of counsel, Mr. Ambrose does raise some, I think, are legitimate issues regarding defense strategy. Both parties know that many of these decisions not to call witnesses or not to question about certain things or not to raise certain defenses are a matter of trial strategy. However, the court feels that that record needs to be developed more with Mr. Johnson, Ms. Vander Ark's trial counsel. In particular, of concern to the court is the allegation that Ms. Vander Ark did not authorize Mr. Johnson to essentially concede guilt to voluntary manslaughter. That is a pretty significant issue, which many times leads to reversal and a new trial if that actually can be proved to be true. I don't know that, but I think I think it's irresponsible of the court to simply make a decision on that based on just briefs without further developing that issue. So in regards to the motion for a new trial based on ineffective assistance of counsel, the court is going to grant the defense a Ginther hearing for those issues raised in the brief. That will not occur today. As I indicated, Mr. Ambrose would like his client here for questioning, and I think that is a reasonable request based on this motion. So the court will set that for a further evidentiary hearing at a later date. Mr. Ambrose, anything clarification from the court that you'd like, or any issues that you have for the court at this time?
Just one thing, and I put in my brief that I never did receive that waiver. And if I can just put the written waiver on the record of what was signed by my client.
Yeah, that's fine. That's fine.
It says, I, Shanda Vander Ark, defendant, agree to waive my right to be in the courtroom during the trial of Timothy Ferguson. I mean, and that's dated December 15th, 2023. So it seems somewhat, and I just received this today. Because in my review of the court file. Now, if that has any impact, if the court wants to evaluate that, maybe my client didn't. She's obviously, her record, her past, her history, she's pretty much on top of things. Doesn't
Oh my gosh, they need
Like
to
I
meet
said, I
her.
made my ruling. It doesn't change my ruling, Mr. Ambrose, but I appreciate that bringing that to the court's attention. So.
Hi,
I
Annabelle.
also want to make it clear for the record, the waiver was in the court file. Unfortunately, it was misscanned in circuit court. It was actually attached to the jury verdict. So when the court received the motion, I looked for it too, and I could not find it. And eventually my staff realized that it was actually scanned inadvertently on the there's a second page of the jury verdict, which it should have been separated out. So I think it should have been provided to you as part of the court file, Mr. Ambrose, if you received the jury verdict. But I don't know. Like I said, it may or may not have been in the material, but if you ask for the record, it should have been in there because it was a digital copy, but I won't hold you to it. Anyway, Ms. Bloomquist?
Nothing further from the people, Your Honor.
All right. So the court will schedule this for a Ginther hearing at a later date. Thank you on both well-written briefs, good arguments, and we'll see you at a later date. So we're adjourned.
Why did he just not bring her today? Like, just get it done. This is. Oh, hang on. Well, Holly, I wish you all the best and quick recovery for your surgery. I hope everything goes well, and we'll see you when you get back. So take care of yourself and heal up quickly. Yeah, I'm not if he knew that that's what was going to happen, that he wanted her there, just get her there. Like, everybody was there. That's ridiculous. And it's a waste of time. And there's no way that after watching her defense attorney, Mr. Johnson, in interviews after that trial was over. Ooh, Ollie, that's a big one. Yeah, yep. That's a big one. Yeah, I really wish you a very speedy recovery on that. I don't think there is any way in this entire world, if you had to pick people that would forge something, you would ever pick Mr. Johnson. Like, he just would not, he wouldn't. Now, there's been people that have surprised you and they've done things, or surprised me, and they've done things that you're like, you would think they would never do that. And then they did that. Boy, that would be, that'd be something. That would be something. I don't believe he did anything that he should not have done. I don't believe he forged anything. I don't believe he signed anything for her. I don't believe that she didn't understand everything that was happening. She didn't want the jury questions. She didn't want to have to answer to the jury. That's my thoughts on her little thing. And we didn't see her little panic attack or whatever happened the 8 minutes after the questioning was done, because that's, the courtroom cameraman he was clocked out and just cut everything off. So we didn't see that. I think that was her way to get out of the jury questions. She never came back. She would have done something else when they were playing that video of her from her, the cameras that she had inside her home that showed what she did to Timothy during the last few hours of his life and how she treated him. She would have done something then to delay that. She knows what she's doing. She's an intelligent woman. She told us all about how intelligent she is. Except I don't know how she remembered how intelligent she was, because she can't remember anything. Oh, yeah. Well, she just wanted everything recovered because, she put clothes on Timothy so he couldn't see what happened to him. He couldn't see that he had starved to death. Yeah, she probably would. Who knows what she would. I don't know. I don't know what she would have done. But this is kind of frustrating that the judge is going to allow that. They should have just said, if you're going to, Mr. Johnson was right there. Like, they knew he might testify. She has contraband, since she must be what? Sorry, I want that to stop spinning at me. Bree? What's wrong with you? Oh my goodness. Well, no braids today. That was disappointing. At least on the competency part, he did rule denied. She'll appeal it. It'll be denied. There's nothing that showed she was competent. Nothing. But this whole thing with Mr. Johnson, this is crap. So that's my opinion. Not that anybody cares about that. But do you suppose maybe did he watch us watching the trial? We said nice things about him. And the judge's like, I already watched the trial. Did he have good audio? I would have been like, nope. If it was really that important, she should have been there. Yep, just like today. Should have been there. Why is she not there? Like, where is she? I don't know how far away she is from the courthouse. But it's not like they didn't know the hearing was coming up. Just transport her. You guys did that all the time. Or you do it every day. Maybe he's allowing so she can't say it was done wrong or something. I don't know. You're thinking about all the things that didn't happen, that she had contraband. Only contraband she needs is hot sauce and bread, stale bread. And not the hot sauce you get at Meijer, because that's not good enough for her. I don't, Flash fan. Why would you say that? Are you angry? I'm pretty happy that no one's coming after me in the comment section. Wait, they might for yesterday's video because of the audio thing. I don't know. That happened in the first one, and I had a lot of people complain. But like I said, some people could hear, some people couldn't. I don't know. I couldn't fix it. It like Shenny said, it was in the court. Not like that. Well, that's what you said. Well, dang it. I thought we were going to send her away forever today. Kind of bummed, a little irritated that we're not. Like, she just won't go away. But absolutely think 100%. But she was shaking her head no at the judge. I'm like, shut, just stop. But also, there was like these two there was a lock and something else that was on the screen. Because at first I thought they had a big shackle around her wrist, but then she raised it up. Like, what's on your screen? And wouldn't that be hilarious if it was like the dog filter, like that happened to that one guy that his granddaughter or something had put a filter on his iPad when he had a meeting and it kept making him like a dog or something, like off Snapchat. I love you too, Dill. Flashbrand said it like I wish a mother effer would. I don't want it to. I know there would be, but I don't want there to have to be. Like, thank you. But okay, no. It'll all be okay. So Monday, we will go back to the Betty Broderick trial. Finally, that's going to seem normal after this, and it has great audio. We are going back to the defense is presenting their case, and just kind of like this defense, there's not much. There is not much of one. So that will be Monday at 6 p.m. Eastern time. We'll get back to Betty. The squeakiest chairs in the world, and maybe some mannequins, although I don't anticipate them making a return at this point, which is sad. If I had the mannequins, I would put them right behind me, just so you guys could see them. Well, I am proud. Well, I thank you, Flash fan. I just don't hope you don't have to. So now what? Well, now it's over. It's over. Mad Dog hasn't been a special guest with me in a while. That's because she was when Carmen was here. I forget what we were doing. And I had her and she started reaching for everything. And I was like, this is why this is why I don't stream on Fridays anymore, because she's too active now. I hope they do. I hope the mannequins come back. If the defense wanted to give, or if the prosecutor wanted to give a great closing argument in the Betty Broderick trial, put the bed back in there and the bloody sheets back on the bed and the mannequins back on the bed, and do what she did when she cross-examined that expert that had the ruler that kept measuring the sheets. That was so funny. Do that. Flashman, if we need you to read like a woman again, you will read like a woman again. Yes, she was reaching for everything. But you should make an intro that just has mannequins. Maybe I will, Gabby. Maybe I will. Puddletown would he'd be in love. He'd be in love. And don't scare me. Indiana women are scary. Why? Is it because of the corn sweat? Flashback is the best thing. Also, Gabby, the other great was when on Valentine's Day when Flashman was on? And there was pickup lines in the chat, and then Flashman started giving his own pickup lines. That was hilarious. Like, hey girl, Flashman, I know you like Popeyes, and I saw a commercial for them. It grossed me out because that pickle juice is gross, and they had pickle flavored lemonade. So you could use that and be like, hey girl, you want to go get some lemonade that tastes like pickles and some chicken with some pickles and all the pickle stuff. I can't even finish it because then I'd be like, and later I'll give you a different pickle. Sorry, Flashman. I'm sorry, Flashman. I'm in trouble now. I can't. Hey, you came up with some lines. They were funny and they were all about food. All right. Well, sorry. That will probably be me the rest of the day. I might not be talking to anybody, but my dogs will be around. They'll like my jokes. They'll do it. So she's starting in 10 minutes. And she has been so kind to me all week to send her stream over here. You did. You did. I will. Yeah, so I'm going to send everybody over to Ada. Please stop it just and say hello because she has not before you say hello to Ada because she's been so kind to redirect to me like every day this week. So I want to return the favor. Yeah, you better go get it. I'm going to send you over to I'm going to send you over to Valo. I'm going to send you over to Ada. So you guys, thank you so much for joining me. Have a great day. I guess we'll see what happens and I'll keep track of when this is going to happen again. And hopefully I'll be able to do it again. And then we can maybe just have the last time with Shanda and send her away forever and ever and never have to hear from her again. Have a great weekend. Make good choices. Stay safe. As always, I only have enough bail money for Gabby. So I'll see you guys all on Monday. And yeah, see ya. Bye.